Good evening, ladies and gentlemen, and a very warm welcome to this Current Legal Problems lecture. My name is Professor Paul Mitchell. I'm one of the editors of the Current Legal Problems series. And my role this evening is to act as host and to introduce our chair. We're absolutely delighted and honoured that this evening the lecture will be chaired by the Honourable George Brandis QC, who has been Australia's High Commissioner to the United Kingdom since 2018. Mr. Brandis is a barrister by profession, and he practiced mainly in the commercial jurisdiction and specialised in equity and competition law. He was also, I had to admit I hadn't realised, he also was a lecturer in jurisprudence at the University of Queensland Law School for several years. So the lecture theatre isn't a kind of a foreign environment. Subsequently, Mr. Brandis has been a member of the Australian Senate for 18 years, serving as a minister in the governments of Prime Ministers John Howard, Tony Abbott, and Malcolm Turnbull. He was also Australia's Attorney General from 2013 to 2017 and the leader of the government in the Senate in Mr. Turnbull's government. As Attorney General, he reformed Australia's human rights laws. He was the architect of its foreign interference laws and played a leading role in the enactment of marriage equality in 2017. We're absolutely delighted and honoured to have you chair this lecture. High Commissioner, thank you very much indeed for being with us this evening.
Well, thank you very much, Professor Mitchell, and I can't tell you how honoured I feel to be invited to chair this evening's lecture in the Current Legal Problems series, hosted by University College London. The lecture tonight will be delivered by Professor Mark Lunny, a distinguished Australian legal scholar whose particular areas of academic specialisation are legal history and the law of tort. Among his published works, Professor Lunny in 2018 published a monograph, The History of Australian Tort Law, 1901 to 1945, England's Obedient Servant. He is the lead author of one of the leading tort law case books, Tort Law Texts and Materials, which is now in its 6th edition, and also one of the authors of The Law of Torts in Australia. Professor Lunny is both a Professor of Law at King's College London, a visiting Professor of Law at University College London, and a Professor of Law at the University of New England in New South Wales, from where he joins us very early in the morning in Australia from the city of Armidale. The topic of the lecture, From Parker to the Australia Acts, Sir Victor Windeyer and the short-lived triumph of the independent Australian Britons. A fascinating topic. It promises to be a real intellectual feast. So can I now invite Professor Mark Lunny to address us.
Thank you very much, High Commissioner, for those kind words of introduction and for chairing tonight's lecture. I'd normally begin a lecture such as this by saying how pleased I was to be here. Of course, I'm delighted and honoured to be asked to give a lecture in this series, and it's disappointing I can't be there at UCL tonight, but through the magic of modern technology, I can sit in my office in Armidale and deliver the lecture. Can I also give a particular shout out to the Australians who have got up at a very uncongenial hour to listen to this lecture, in particular through the Francis Forbes Society for Australian Legal History, for whom I'm a junior vice president. In 1986, the last vestiges of Australia's imperial common law past was eradicated by the passage through the Commonwealth State and Westminster Parliaments of the Australia Acts. Eminent judges noted the sense of liberation that this legislation provided. On its face, however, this seems This sense of the throwing off of the imperial yoke is difficult to understand. Whatever the formal limitations that were removed by the Australia Acts, Australian courts had, since the end of the Second World War, been increasingly free to do their own thing. I have elsewhere argued that the notion that, in the earlier period, Australian courts bristled under the weight of an imported legal system misrepresents the self-understanding of Australian lawyers. Australian judges and lawyers saw themselves as contributing to the common law, a shared resource of the British race. True enough, their contributions were rarely appreciated back home, but that did not change the commitment of Australian lawyers to the grand corporate project of developing their common law. The common law was part of the heritage that Australians took because they were British, and being British defined who they were. Adopting the historian Keith Hancock's lens of Australia as a nation of independent Australian Britons, Australia's common lawyers were bilocated physically in Australia and emotionally in an almost metaphysical common law. The changed political dynamics after the Second World War meant that this view would come under threat. The nature and scale of the threat and the impacts this had on the demise of the imperial embrace, as the historian Stuart Ward puts it, remain contested in Australian historiography. Broadly, the competing views take issue over the ubiquity of British race patriotism as a defining feature of representations of Australian national identity. Politics, art, literature, economics, and elements of civil society have formed the battleground for these debates. Law has been largely absent for perhaps two reasons. One reason is that historians have been put off by the technical expertise required to unpack legal development. More broadly, however, the law may have seemed a less fertile area for analysis given the constraints imposed by the doctrine of precedent. While there were clearly some areas where law was distinctively Australian, such as constitutional law, the common law, especially in private law, was seen as essentially derivative and based on the law as declared in English courts. On that view, 1986 is a landmark because it represented the final victory for an Indigenous Australian law. My argument tonight does not at all take issue with the significance of 1986. But what I do want to suggest is that the path to the liberation of 1986 was not the path of liberation that lawyers of a generation earlier might have envisaged. The conventional narrative of the road to a judicial epiphany lies in what is known as the thwarted nationalism view of Australian identity. As Ward describes it, under this framework, the element of antagonism in Anglo-Australian relations remains paramount as the pernicious influence of British race patriotism raises its head to thwart Australian nationalists at every point where they might otherwise have grasped the method of independence. An analytical framework has become firmly entrenched in which independence is equated with defiance, self-assertion with divergence, autonomy with antagonism. Conversely, those Australian political or cultural figures deemed to have identified too closely with the British connection are looked upon as a national disgrace. Although the development of an Australian law was not the focus of the critique, the story of the gradual emergence by fits and starts from imperial servitude to a newly fledged judicial independence fits well within the thwarted nationalism framework. For example, Paul Finn has quite recently discussed the journey to Australian judicial freedom from the Privy Council as a linear one, beginning with the well-documented unhappiness by some members of the Australian High Court with the decisions of the Privy Council and concluding with the final emancipation in the Australia Acts of 1986. In this lecture, I want to suggest that the path to Australian judicial independence was not quite so linear as accounts such as Finn's suggests. Using the tort judgments and writings of Sir Victor Windeyer, a judge of the High Court of Australia between 1958 and 1972, one of Australia's most important legal figures of the post-war period, as a base, I want to suggest that the key moment in the development of Australian legal independence was not 1986 but 1963, when the High Court of Australia in Parker against the Crown first held itself free to depart from the decisions of the House of Lords. Moreover, I want to suggest that it was the rationalising of the events of 1963 by the independent Australian Britons of Windier's generation that led to 1963 being seen as an event that stressed continuity as much as change. Together with the 1966 practice statement of the House of Lords, allowing their lordships to depart from their own previous decisions, the decision in Parker and its immediate aftermath, for a brief period, gave rise to the ideal of a new cooperative Commonwealth legal system based on equality and the abstract merits of legal arguments. By the early 1970s, however, this vision of a judicial Camelot was proving elusive. Once this vision for the future of Anglo-Australian legal relations had receded, the time was right for a new, more brazen Australianness in Australian law, of which the Australia Acts of 1986 was the culmination. So the story, in fact, begins in 1961. In DPP and Smith, the House of Lords held that it was sufficient to satisfy the mens rea requirement for murder if a reasonable person in the position of the accused would have contemplated the accused's conduct was likely to cause grievous bodily harm to another. This decision prompted the well-known comment of High Court of Australia Justice Sir Wilfrid Fullagar to Sir Owen Dixon, "Well, Dixon, they're hanging men for manslaughter in England now." When the High Court of Australia came to consider the question 2 years later in Parker against the Crown, Chief Justice Dixon wrote on behalf of all members of the court, including Windia, "I say too unfortunately, for I think it, Smith, forces a critical situation in our dominion relation to the judicial authority as precedents of decisions in England. Hitherto I have thought that we ought to follow decisions of the House of Lords at the expense of our own opinions in cases decided here. But having carefully studied Smith's case, I think that we cannot adhere to that view or policy. There are propositions laid down in the judgment which I believe to be misconceived and wrong. They are fundamental and they are propositions I could never bring myself to accept. I wish there to be no misunderstanding on the subject. I shall not depart from the law on the matter, as we had long since laid it down in this court, and I think Smith's case should not be used as authority in Australia at all." The language used by Chief Justice Dixon in announcing this change of practice is striking. It should be remembered that as a matter of strict precedent, the High Court of Australia had never been bound by decisions of the House of Lords, or indeed of lower courts in the English hierarchy like the Court of Appeal. These courts were not part of the judicial hierarchy in Australia. From early in its history, however, the High Court had adopted the practice of considering itself bound by decisions of the House of Lords, and sometimes even by decisions of the English Court of Appeal, as a matter of comity, out of respect for the broad imperial lens through which decisions of, particularly the House of Lords, needed to be viewed. In perhaps its most considered reflections on the question, in Pirro and W. Foster and Co. Limited in 1943, the High Court indicated that it would follow later decisions of the House of Lords in preference to earlier inconsistent decisions of its own. However, by the late 1950s, the enthusiasm for the position expressed in Pirro was waning. A High Court decision from 1959, Commissioner for Railways, New South Wales and Scott, for example, Chief Justice Dixon commented wryly, "Uncorrected, I am afraid that I should have said that the Commissioner might recover damages appropriately measured from the wrongdoer in an action per quod sedition omissit, before demolishing the reasoning of the English cases which led him to reach the opposite conclusion." In the light of this progression, it is somewhat surprising to see the gravity in Dixon's pronouncement. In many ways, the statement in Parker was a logical progression from what had gone before it. But the relation of dominion legal authority to English precedents was only a part of a much wider realignment that was being forced on Australia in its relationship with the United Kingdom. The historian Stuart Ward has argued that despite occasional and sometimes profound disagreement, Anglo-Australian relations played out within the context of a British race patriotism that was seen to bind Australia to the United Kingdom, and that extended to the immediate post-war world. Ward argues, however, that this relationship was terminally fractured by the decision of the Macmillan government in the United Kingdom to seek membership of the European Economic Community. The initial hostility and sense of betrayal typified by public pronouncements of Australian Deputy Prime Minister Jack McEwen, he eventually gave way to resignation that the break would come and that Australia would sooner or later have to look out for itself. The ultimate veto by de Gaulle of this attempt did nothing to change the situation. Both sides would realised a major realignment was necessary. Parker was argued before the High Court in August 1962 and judgment was delivered in May 1963. It's difficult not to see the choice of expression, critical situation in our Dominion relations to the judicial authority as precedents of decisions in England, as being influenced by the wider changes to the Anglo-Australian relationship that was unfolding. More broadly, the Parker decision was made in the midst of a wider cultural and intellectual milieu that was exploring and promulgating new models of Australian identity. In 1958, for example, Russell Ward published The Australian Legend, arguing that Australian nationalism was derived not from the Anglo-Australians who saw Britain as home, but from the independent pioneering bushworkers who had carved out a series of qualities that were distinctly Australian, qualities not associated with Hancock's independent Australian Britons. And in 1962, Manning Clark published the first volume of his History of Australia, stressing the importance of the Australian physical environment to the development of European civilization in Australia. The intellectual milieu was certainly ripe for Australia's highest court to formally break from its past traditions. Exactly what that would mean in practice, however, was less clear. One of the members of the higher court who would decide what the new freedom meant was Sir Victor Windeyer. The Windia family, of which he formed part, had a distinguished and long-standing connections in New South Wales. His father was a solicitor, his uncle a King's Counsel, his grandfather was twice an Attorney General and a judge of the Supreme Court of New South Wales, and his great-grandfather was a barrister and an elected member of the first partly elected Legislative Council in New South Wales in 1843. This was a family steeped in the world of British Australia. Apart from his family background, Windia himself was immersed in the history of the common law. He'd given lectures for law students at the University of Sydney on this subject while at the bar, and these were later published in a much respected volume. Apart from law, Victor Windeyer is remembered in Australia for his distinguished military career. He commanded a battalion at the siege of Tobruk and was a brigadier during the Battle of El Alamein and later in New Guinea and Borneo. Windeyer's reminiscences on the death of the Field Marshal Lord Montgomery, whom he met while in command in North Africa, is a powerful testament to the connection felt to this British commander. The image of Montgomery wearing an Australian slouch hat and seeking an Australian Imperial Force Rising Sun badge when he visited Windeyer's command, explained by Montgomery on the basis that his father was Bishop of Tasmania, were tangible reminders of the common bond believed to be shared by members of the British race. For Windeyer, the common law was part of that common bond, and while the decision in Parker against the Crown was hardly an abrupt termination of that bond, it was nonetheless a statement of intent, but of what intent? Windeyer's contribution to the solving of this dilemma came through his membership of the High Court benches that next faced the question of what to do with unwanted English authority. The first came in an area of a particular judicial interest for Windeyer, awards of damages in personal injury actions. A common theme of his judgments in this area was the difference between injury to earning capacity, which was objective and could be valued by reference to economic criteria, even if only imperfectly, and damages for non-pecuniary loss, which had no such objective base. For this latter head of damages, he introduced a theme that would receive greater prominence in later judgments, that damages for non-pecuniary loss were related to the subjective ability of the plaintiff to receive benefit from them. He discussed this first in 1961 in the case Thatcher and Charles, and 2 years later he elaborated his thinking in Teubner and Humble. Awards of non-pecuniary loss were made to provide substitutes for the lifestyle that was lost as a result of the tort, and their validity depended on their being able to be appreciated and used for that purpose. He said, "I have considered what has been said in the reported cases about objective as against subjective tests in this connection, but until the matter be definitely concluded by a considered judgment of this court or by some authority binding on us, I am not prepared to accept the view that damages for loss of enjoyment, loss of amenities can properly exceed any sum that the injured person can in any way enjoy, which can be used to provide him with comforts or amenities." The choice of words Windeyer used to describe the authority that would be required to change his view is telling. In April of 1966, Windeyer gave a speech to the New Zealand Law Society Conference in Dunedin on unity and disunity in the common law. 1 month earlier, he had delivered a judgment in Skelton and Collins, where he said that his judgment was not the place for an essay on jurisprudence or a full consideration of the theoretical problem of reconciling common heritage of doctrine with the development of differing doctrines. It is tempting to think that the questions raised in Skelton and Collins, which I will discuss shortly, prompted Windia to garner his thoughts for the lecture the following month. However, it's clear that Windia had been thinking about how to deal with the implications of Parker well before his judgment in Skelton. Windia had been approached to deliver the lecture in the middle of 1965. It was initially suggested that he say something about recent developments in tort law, but Windia suggested, and it was agreed, that he comment on unity and disunity in the common law. This may have been prompted by a proposal for a Commonwealth Court that had been mooted by the English Lord Chancellor, a proposal with he and along with Australian Prime Minister Robert Menzies disagreed. Concerned to avoid comment on a current political issue, Windia nonetheless wanted to say something more general about the demise of the one common law for the empire ideal, of which the High Court decision in Parker had played its part. Viewed in this light, the comments in Teubner about some authority binding on us suggest that the consequences of Parker for aspects of the law of damages and personal injury were in Windia's mind almost as soon as Parker was given. Whatever the original motivation for the lecture, there is no doubt that by the time it was delivered, its form was shaped by two cases that came before the High Court for argument in the second half of 1965. The first was Skelton and Collins, argued in September 1965, with judgment delivered in March 1966, 1 month before Windia's election. While there are other issues relating to quantum of damages, the two main questions for the High Court were whether it should follow the Court of Appeal decisions in England in Wise and Kay and Oliver and Ashman, limiting the claim for damages for loss of earning capacity to the plaintiff's post-tort life expectancy, even if that had been shortened as a result of the tort, and whether the High Court should follow the recent decision of the House of Lords in H. West and Son Limited and Shepherd, deciding by a 3-2 majority that non-pecuniary damages for loss of amenity should be assessed objectively rather than subjectively. By varying majorities, both the established English positions were rejected by the Higher Court. For present purposes, however, it's not Windia's legal reasoning as such that's important, but rather his comments on how earlier English precedent should be handled. As I indicated, he expressly noted in his judgment in Skelton that it was not the place for a detailed exposition of his views on these issues, but such an avenue was available in his New Zealand conference speech delivered the next month. There is in fact much overlap in language, between the judgment in Skelton and the speech, and while there are also differences, I'll focus tonight on the lecture as it expresses more fully Windia's framework for how the old one common law ideal might work in an era where strict legal conformity with English law was not required. He began by pointing out that, in fact, English law had not been a uniform in much of the empire since the 19th century because of the legislative competence granted to self-governing colonies. In Australia, the relative legislative freedom of the Colonial Law's Validity Act of 1865 had resulted in considerable diversity by the middle of the 20th century. In tort law, for example, Australian jurisdictions allowed claims for bereavement, and also a statutory claim for nervous shock, things that were not present in English law. Why then was there misgiving and apprehension at the idea of the common law being developed differently by different courts, each working in the traditional way? He identified two reasons: the pull of race and the declaratory theory of the common law. He spent little time on the latter, no doubt because by the 1960s, the declaratory theory of law was largely discredited, but he was acutely interested in the former. As discussed previously, British race patriotism was a defining component of Australian identity for much of the 20th century Australia. It was profoundly important to Windia. As far back as 1933, when he went to Toronto as part of the Australian delegation to the British Commonwealth Relations Conference, he was confronted with a much more independent position taken by the Canadians to imperial matters and was clearly surprised. Writing to his uncle, he gave a number of reasons for the, quote, strange forms Canadian national pride took, but the most important was race. In the first place, Canadian nationalism is not based, as is Australian national feeling, on common British stock, on federation, and on the achievements of the war years. Equally interesting was the sense of empire he felt when he shared a train with a, no doubt, white menagerie of empire people, a tobacco grower from Rhodesia, a mining engineer from West Africa, New Zealanders, Englishmen, and Australians, all of whom took an interest in pictures of public events in London. The sense of empire, or this sense of empire involving being part of a team, was reinforced by his military service and remained with him all his life. It is no surprise then that Windia trod very carefully when he explained why the casting off of the legal imperial yoke of deference to decisions of English courts, especially the House of Lords, was not an act of disloyalty. At the outset, he pointed out that in case anything he said, quote, should be construed as an unseemly assertion of independence or as a strident Australian nationalism, his family had been a British subjects in a British land for 6 generations, proudly so. Australian and New Zealand war service was also the service of kinsmen, not allies, there because of the pull of race and of history, obedient in their loyalty. The common law was part of this kinship. What we call the common law of England is not the law of a land, but the law of a people, the British peoples, for Scotsmen perforce must accept it when they are overseas. It is not the law of a place, but the customs of our race. It is part of the civilization and culture that is ours. As place was not an essential component of the common law, what features were required for there to be a meaningful common law? While the homogeneous race was necessary, so too was a sufficient degree of economic unity, an organic political unity, and a jurisdictional unity through a court with power to declare the law throughout the country. But if Australia had all these, which he thought it did, how is this common law to be identified? You know, Windier's view, the answer in Australia was the corpus juris, not of Roman law, but of the British common law. Sources included what Australian courts had said, but also English, New Zealand, and the courts of other common law countries. This was not done to quote stuff judgment with numerous exotic references, but eclectically to discover the law. Windia realised that his Catholic approach to identifying the law would inevitably mean that the law could not remain the same everywhere, but did not see this as a matter of regret. We misunderstand our inheritance of the law if we think of it as a number of specific legacies to be selected for us from time to time by courts in England. Rather, it is a share in a general legacy of method and spirit, of doctrine rather than dogma, of general principle rather than other particular rules. In short, a system of law. We must not only accept our inheritance, we must use it. A nation must not only make its own laws, it must for itself expound and apply the law that rules its people. That is the responsibility that accompanies heritage. While the Whiggish undertones are obvious, there was also some realpolitik in Windia's views. Britain was seeking closer ties to Europe, and with a, quote, growing consciousness of our nationhood thus forced upon us, there is coming a greater sense of the realities and responsibilities of our nationhood, a greater sense of destiny. That destiny might encompass pointing away to those newly independent states of the former empire by showing the benefit of accepting English common law by choice, rather than seeing it as an imposition. Whatever the limits of seeing the common law as being enthusiastically adopted by peoples upon whom it had been forced, and who were not of the race of which the common law was a cultural artifact, it was an attempt to recast the place of the common law in a post-empire world. While there are obvious links between Windia's judgment in Skelton and the New Zealand election, it's very likely his thoughts were also affected by 2 cases, both raising the same issue, argued before the High Court in November 1965, Uren and John Fairfax and Company Proprietary Limited, and Uren and Australian Consolidated Press Limited. In Skelton, the High Court had not followed 2 Court of Appeal decisions. That was rare, but not unparalleled. Skelton was also the first time since Parker that a House of Lords decision had not been followed by the High Court. But the result in the Lords in Western Sheppard had only been by a 3-2 majority. And while this is still a very significant choice, there was obviously support amongst the English judiciary for the position taken by the High Court. However, And the House of Lords was asked to, when the High Court was asked to consider whether it should follow a unanimous decision of the House of Lords on the availability of exemplary damages, Rooks and Barnard, there was no minority judgments to which colours could be named. There was also a body of case law in Australia predating Rooks, allowing exemplary damages in a wider category of cases than was allowed in Rooks. Here, the only option was outright disagreement, a course that all members of the High Court took other than Windia himself. But Windia's view was the result of his own interpretation of Lord Devlin's speech, and he was at pains to affirm his position stated in Skelton. The House of Lords had overturned the previous law on exemplary damages. It, quote, it indicates no disrespect for the high authority of their Lordship's House, no breaking of the ties, light as air, if we, having a duty to abide by the law that we have inherited and having in mind the way it has been declared here, feel unable to join in this. Unlike Skelton, however, there was an appeal by one of the parties to the UN litigation to the Privy Council. This gave rise to a problem that was recognised almost as soon as the Parker decision had been handed down. Now, a letter from Viscount Simons to Chief Justice Dixon in June 1963, the former noted that the Parker decision raised no end of a problem. Imagine a case in which special leave is sought to appeal to the Privy Council on the ground that a direction to the jury is in direct conflict with Smith and is opposed on the ground that the Australian High Court has rejected Smith. That is the problem in its nakedness. Viscount Simons suggested what he would do in such cases. The petition would be refused and, quote, I should on this occasion bless the practice of giving no reasons. There had been an important change between when that letter was written and the UN appeal. When Simons had written to Dixon, the House of Lords remained bound by its own previous decisions. So the unenviable task for the Privy Council was either to depart from a decision of the House of Lords, which the latter remained bound by, something that would be undesirable for members of the Judicial Committee when they sat in the Appellate Committee of the House of Lords, or overturn a considered decision of the High Court of Australia, thereby in practice making the High Court bound by a decision of the House of Lords with which it had expressly disagreed. This changed, however, in 1966, when the House of Lords practice statement allowed their lordships to depart from their own previous decisions. Commentators immediately recognised the significance of this event to the future relations between English and Dominion courts. Some went as far to suggest that the practice statement was prompted by the High Court's decisions in Parker and Skelton. Edward St John thought that the day when the carefully considered judgments of the High Court could be ignored by English courts and English lawyers was a passing. In his view, a new relationship of equality and mutual respect has emerged to replace the colonial attitude clearly evident on both sides not so very long ago. This is a natural development and one in which we should rejoice. The first test of this new Eden would come when the Privy Council appeal with the Privy Council appeal in the UN case. But the ultimate decision of the Privy Council in July 1967 was not quite the victory for which the Corpus Juris enthusiasts might have hoped. Rather than reject a decision of the House of Lords given less than 5 years previous, the Privy Council held that this was a case where divergence between English and Australian law could be allowed. The issue that faced the High Court in the present case was whether the law as it had been settled in Australia should be changed. Had the law developed by processes of faulty reasoning, or had it been founded upon misconceptions, it would have been necessary to change it. Such was not the case. In the result, in a sphere of the law where its policy calls for decision, and where its policy in a particular country is fashioned so largely by judicial opinion, it became a question for the High Court to decide whether the decision in Rooks and Barnard compelled a change in what was a well-settled judicial approach in the law of libel in Australia. Their lordships are not prepared to say the High Court were wrong in being unconvinced that a changed approach in Australia was desirable. Windia himself seems to have been somewhat nonplussed by the decision of the Privy Council. Writing to Dean Wilbur Balcott of the Alberta Law School in response to an earlier letter, he noted that he had waited until the decision of the Privy Council before writing. Laconically, he said, well, we know that now, before recognising that the High Court had to henceforth accommodate, I hope wisely, our deep respect for our inheritance of the law with greater independence of in declaring for Australia the law we have inherited. There was certainly evidence that the power of the reasoning that supported the High Court's choice to depart from the House of Lords' decisions on Skelton and the year-end might ultimately herald the kind of multilateral corpus juris to which Windia had referred in his 1966 lecture. In May 1966, all three members of the English Court of Appeal, and Andrews and Freeborough, extolled the virtues of Skelton and Collins over West and Shepherd, before a majority held they were bound by the latter case. And after the Privy Council decision in Aguirre, the noted English academic Robert Houston wrote to Windia, noting that the references by the Privy Council to the intrinsic merits of Lord Devlin's judgments in Rooks and Barnard's, quote, were most skillful in the way they hinted at disapproval without actually stating it. Yet, as the third-year law student at Sydney University, John Lehane, presciently noted, much would depend on whether the Privy Council's attitudes expressed in Aguirre would lead to a lasting change of approach. After Parker, the Privy Council had disapproved the reasoning, if not the result, in an occupiers liability case, Commissioner for Railway New South Wales and Queensland, in the face of a well-developed line of High Court decisions seeking to bring the common law of occupiers liability within the scope of the general law of negligence. Windia had been party to a number of those decisions. As Lehane observed, the approach of the Privy Council in Queensland was a far cry from that taken in Aguirre, and it remained to be seen whether the latter was an aberration, the beginning of a new era, or something in between. The first opportunity to see whether the Privy Council decision in Aguirre heralded a new era also involved a tort case. Evatt and the Mutual Life and Citizens Assurance Company Limited was an action which required an interpretation of Hedley Burn Co Limited and Heller Partners Limited, a seminal decision of the House of Lords from 1963 introducing a liability in tort for negligent misstatement causing financial loss. The legal question raised is whether the defendant needed to be in the business of providing information and advice before a duty of care could be owed to the recipient. The issue was raised squarely in the case because the information had been sought from the defendants in their capacity as members of the same corporate group as the subject company about whom financial advice had been requested, rather than as entities that provided information or advice as part of their business. A majority in the High Court held that the Hedley Burn duty could extend beyond those entities or individuals that provided information as part of their business to those who held special information on which the plaintiff had reasonably relied. It's not necessary for present purposes to go into the detail of the five judgments, but it is clear that they all recognise the importance of the case in terms of delimiting the Hedley Burn duty. All were considered judgments that interrogated Hedley Burn and the authorities on which it was founded. Three members of the High Court in Evatt had sat on both the Skelton and Aguirre cases, and one other, Justice Kiddo, on Skelton. They did not feel it necessary to revisit the territory of the relationship between the decisions of the House of Lords and the High Court, and in any event, the issue in Evatt was the scope of the House of Lords' decision rather than its correctness. Nonetheless, there is nothing in those judgments to indicate any dissent from the comments of Chief Justice Barwick on the wider question. Barwick had not sat on the early cases, so perhaps he felt it necessary to explain his view. The matter, so far as this court is concerned, is free from any binding authority. The court's task, therefore, is to declare the common law in this respect for Australia. There are indicative decisions of the courts of England. These are to be regarded and respected. With the aid of these and of any decisions of courts of other countries which follow the common law, and of its own understanding of the common law, its history and its development, the court's task is to express what is the law on this subject as appropriate to current times in Australia. This will not necessarily be identical with the common law of England, though it may always be preferable if substantial divergence between the two can be avoided. Windia didn't sit on the Evatt case, but there are obvious continuities between his comments in Skelton and Barwick's views in Evatt. Barwick returned to this theme in the Lionel Cohen lecture he gave at the Hebrew University of Jerusalem in June 1969. He mused whether the Privy Council decision in Aguirre had given what may yet prove the final creators to the endeavour of maintaining uniformity on matters of general principle. And he was unimpressed by the Privy Council's attempt to paper over this problem by identifying different social conditions between Australia and the United Kingdom. I cannot call to mind any purely Australian circumstances which call for differential treatment as to the award of exemplary damages in defamation. Like Windia, Well, Barwick did not see the diversity in application of the common law necessarily meant a lack of cohesion. The basic and abiding elements of interpreting the common law and statutory construction may produce a uniformity more meaningful than identity in a particular solution. The leading Australian academic, F.K.H. Marr, said something similar in an article published the same year. Perhaps the most enthusiastic advocate was the youthful John Latham Professor of Public Law, David Jackson, who looked forward to the creation of a judicial commonwealth. As he put it, what is being urged in this article is not uniformity of development, but a development within the Commonwealth, and particularly in England, with the judicial steps taken elsewhere in mind. It is suggested that the type of approach set out by Barwick and MLC Assurance Company Limited and Evatt should be adopted by all Commonwealth courts. Like development should be as conscious as divergent. While different development is not lamentable, knowing different development is. Outside events pulled in the same direction. In Australia, the Commonwealth Parliament in 1968 legislated to restrict appeals to the Privy Council on matters of federal law. The confidence that a new era had come about was expressed by the editor of the Australian Law Journal's comment on the prospects for the Evatt decision when it went on appeal to the Privy Council. The judgment examined Headley-Byrne not in order to find the correct principles with that case established, but rather as a decision of assistance to the court in formulating the law for this country. In these circumstances, intervention by the Privy Council adverse to the majority seems unlikely. So it came as a shock when the Privy Council overturned the High Court decision in Evatt in a 3-2 decision. Nowhere in the majority opinions is there a reference to whether the social conditions in Australia might justify the approach taken by the High Court. It was certainly arguable that the extent of liability that should be allowed from the transmission of specialised information and advice depended on the availability and market for such advice in the jurisdiction in question, and that was a matter for the High Court. More generally, however, could the decision be said to be based on faulty reasons and misconceptions? In a powerful dissent, 2 of the 3 members of the Privy Council who had actually sat on Headley-Byrne, Lords Reid and Morris, supported the interpretation of their speeches by the majority of the High Court. Reviewing Barwin's Cohen lecture when published as a pamphlet, Marr's enthusiasm for the grand project of the unity of common law method was now tempered. The decision of the Privy Council in the Evatt case, quote, shows the inevitable difference as to applying the principles laid down and accepted by all the judges on the High Court, the Privy Council and the House of Lords. This was a fudge. The question in Evatt was not the application of settled principles, but the scope of a new principle. The editor of the Australian Law Journal, which confidently forecast affirmation of the High Court decision, pitifully noted, we were wrong. As Lehane had wondered, the Privy Council's deference in the UN was in fact an aberration, a short-term fix. The confidence in the superiority of the High Court's reasoning and UN over that of Lord Devlin and Rooks also proved misguided. When their lordships reconsidered Rooks and Broome and Castle and Co. in 1972, there was no clamour for Rooks to be overturned in favour of the UN line, a 3-2 majority upholding it. While some of their lordships cited the judgments of Justice Windia and Justice Taylor in their speeches, the unanimous decision of the High Court in UN rejecting Rooks did not cause a change of heart among their lordships. Lord Diplock saw the different policy judgment of the courts in Australia, New Zealand and some Canadian jurisdictions in rejecting the Rooks limitation as cogent grounds for reconsidering the decision, but not for rejecting it if it was, as he thought, a step in the right direction. Viewed in the abstract, there is nothing in Broome that went against the idea of a corpus juris of Commonwealth common law. For that ideal to have meaning, however, required English courts to concede that, in practice as well as in theory, Commonwealth case law would have the better of the arguments. In that respect, I'll have it die hard. Hence, Lord Hailsham and Broome thought, with no doubt unintended irony, that a Commonwealth courts might actually modify some of their criticism of Rooks in light of the case or decision. However well meant, it's hard not to see this as reflecting an imperial past in which English pronouncements on the common law deserved, if not automatic supremacy, then at least automatic priority. This was not the judicial commonwealth which Jackson had enthused. I found no evidence of a Windia's response to these precise developments, but from the late 1960s through his retirement from the High Court in February 1972, and until he ceased the travelling in the late 1970s, he corresponded with leading legal figures in England, both judges and academics. In one telling letter, Lord Salmon told Windia that he recognised the treatment of the Australian cases of the 1960s had not been ideal. Especially interesting are his comments on the Western Shepherd, Brooks and Barnard and Broome and Castle and Co. cases. I wish that the PC in the Uran and the HL and Broome and Castle had been more robust in dealing with Brooks and Barnard. I think that there may well be a strong case for abolishing punitive damages altogether by statute, but none for conjuring out of the air artificial distinctions upon the doctrine, as Pat Devlin attempted to do in R&B. I hope that the HL has another chance of looking at Western Shepherd. At the same time, judicial correspondents were lauding the quality of Australian judicial judgments. Justice Cumming Bruce, for example, told Windia, I have long held that Australian judges are the best bunch in the Anglo-Saxon system, and if in doubt, I hunt for an Australian authority. Slightly more wistfully, when they were both old men, Denning wrote to Windia that Windia's judgments were landmarks in the High Court, the first he turned to when a High Court case was cited. And there were also defiant statements about what Lord Wilberforce called the alienisation policy, proposals to require visas for members of the old dominions, including Australia, to enter Britain, thought to be a consequence of entry into the European Economic Community. After consoling himself as much as Windia that in practice entry rights would not be much affected, Wilberforce concluded defiantly, whatever the Treaty of Rome that may say, Australians and New Zealanders, so long as they keep coming, will be underlined us and not visitors. What's to be made of all this? On a personal level, the ties between Windia and his English colleagues were close and genuine, but the wider context could not be ignored. Apart from the challenges to the UK's accession to the European community, which played a significant role in forcing a rethink of Australia's self-conception of its identity and its place, as well as its place in the world, the emergence of Australian legal independence had not been taken on board by the Privy Council or House of Lords by the creation of a new judicial Commonwealth. It was one thing to privately tell Windia that Australian judicial views should be given more weight, whilst assuring him of his and his countrymen and women's continuing a connectedness despite the political changes that were plainly suggesting the opposite. It was another thing to give this some public content. It would have been unrealistic to think that every decision of higher English courts would have preferred Commonwealth authority to its own, but at least some wins for the latter were needed to give the idea of a new legal order some credence. Lord Hailsham recognised the writing on the wall when he wrote to Windia in April 1972. I hope that not only you, but all in Australia will realise the sincerity and warmth of your welcome here, and the importance of fostering the personal and, where possible, the constitutional links between us. Personal links could remain grounded in British-based patriotism, but the challenge to more formal links was much greater, especially in an era of self-confessed British decline. Windia returned to these themes in his last major lecture in the United Kingdom, the 1977 Commonwealth Lecture, delivered at St John's College, Cambridge in November. The lecture, Australia in the Commonwealth, is an overview of both Australia's imperial history and its forced adaptation from a dominion to the empire to a member of the Commonwealth. Windia was 77 when he gave the lecture, and elements of it reflect a wistful restatement of past truth as much as a realistic assessment of Australia's new place in the world. To the suggestion that Australia was or should become an Asian country, Windia's response was that in the customs and habits of its people, it is derivatively and essentially a British land with history of England as the mainstream of their history and an inheritance of the law of England, parliamentary governance, Shakespeare, cricket and rugby football. Legal ties remain central to Windia's vision of the closeness of their British-Australian relationship in the post-empire world. The idea of service to his people under the Union Jack, with which he finished his lecture, was a core belief of the independent Australian Britons of which he formed part. The idea had always had its contradictions, as pointed out by one of its greatest advocates, Keith Hancock, in 1937. But shorn of the unifying influence of empire, it increasingly resembled a rhetorical tool clung to by people struggling to comprehend what might replace it in a world where the certainty of the past had been replaced by the contingencies of the future. Windia recognised the factors that were changing Australian society by 1977, in particular changes to immigration, but could not bring himself to admit that the British race patriotism that underlay his sentiments were no longer justified in modern Australia. By 1977, the formal links were fast fading. The government had sought to end appeals to the Privy Council, but was thwarted by recalcitrant state governments playing politics, as much as demonstrating a commitment to the old deal. Whitlam went as far as he could, barring appeals from the High Court to the Privy Council in 1975. Less than 6 months after Windier's election, all 5 members of the High Court held in vero against the Crown that this legislation required that the High Court no longer be bound by decisions of the Privy Council, whether before or after the commencement of the legislation. The unsatisfactory position which remained for state courts, possibly having the decisions of 2 courts, the High Court and the Privy Council, binding on them, inevitably meant that pressure would come to end the final judicial connections, a move that was accompanied by the Australia Acts of 1986. The common law would remain a shared cultural heritage between Britain and Australia. The sharing was done by partners tied by history rather than British race patriotism. Windia understood that political changes in Britain in the 1960s had changed the nature of Australia's legal relationship with Britain. His idea of corpus juris as the de facto substitute has in one sense largely emerged. The supreme judicial bodies of Commonwealth countries, especially the old dominions, continued to this day to consult decisions of similarly situated courts. Windia would have approved. The point here is not that the independent Australian Britons of Windia's generation were completely off the mark in the new model they envisaged for post-empire legal interaction. Rather, it is the normative underpinnings of the of the process that subtly altered from one more directly influenced by membership of the British race to inheriting more abstract traditions that were valuable in their own right. For Windia, British race patriotism was at the heart of the legal traditions and rules inherited by Australians, and that informed his commitment to the Commonwealth corpus juris. While Windia did not think that required legal rules to be uniform amongst countries, it did require an attempt to engage with the merits of its decisions, free from the power imbalances that had historically favoured English courts when dealing with Australian cases. Australian cases were largely ignored until the 1960s, and any enthusiasm from the Privy Council's deference in the Uren appeal was soon diminished by the Privy Council's decision in Evatt and the House of Lords' decision in Broome. It is no surprise that the final release from these strictures of imperial precedent ushered in by the Australia Acts brought forward a genuine sense that Australian law was now truly free. Hopes of the independent Australian Britons that greater judicial independence could be married with a traditional British race patriotism were ultimately, if inevitably, disappointed. Thank you.
Well, thank you very much indeed, Professor Lunny. That was a fascinating lecture. We have a short period of time for questions, and can I remind those attending the lecture that you can type your questions into the Q&A box, and if we have time, we will try and reach them. But we do have a question from Professor Paul Mitchell, with which we'll start. Professor Mitchell asked, did the judges' educational backgrounds, in particular, whether they studied in Britain, have any influence on their attitude to English common law?
It's not something I've looked at explicitly. I mean, Justice Windia was studied at the University of Sydney, so there's no background there. I mean, I think as we go on throughout the 20th century, I think that has some influence, but I think perhaps that influence might be overstated. I've not seen any direct correlation, I think, with educational background and commitment to British race patriotism as a foundation of Australian law. You can look at people like Dixon and Evatt, both of whom studied in Australia, and I think were British race patriots in the Evatt sense. So I don't think that's a necessary link.
And I suppose conversely, in more recent years, there have actually been a larger proportion of members of the High Court who did their postgraduate study in England than at an earlier time in Australian history, including in the current court.
Yeah, that's right.
Another question from Professor Mitchell. Is it perhaps significant that the Australian judges departed from English law in areas where the general public would immediately notice and understand the change? For example, the definition of intention in murder and the amount of damages.
Yeah, it's also a very good question. I mean, I've not seen that addressed in any of the literature, or indeed any of the correspondence. I mean, clearly, I think the refusal to follow DPP and Smith in the Parker is, I mean, it's got a public impact, but I think it really goes to the root of a deep philosophical commitment. But I also think, and this is not entirely new, but I don't perhaps think it's been stressed so efficiently, that this is also playing into a sense that things are changing with our relationship with Britain. I didn't have time to at night, but indeed the High Commissioner may have some experience of this as well. But there's a sense of betrayal that takes place, that Britain would do this unto us. So either have lived for the last 20 years in regional Australia, and there are still people here in their 80s now who look back on what Britain did to us. They're expressing what Britain did to us in the 60s. So they absolutely be traitors. So I think what's more significant is simply the timings rather than the specific subject and the matters that the High Court chose to be apart from House of Lords cases.
All right, thank you. We have a question from Professor Charles Mitchell, which I'll read. I should say it's quite a conversational question, so it'll take me a little while to read it. Professor Charles Mitchell writes, "Thank you for your fascinating talk, Mark. You have given us examples of divergence between the Australian and English jurisdictions drawn from tort law, and shown us what a large part was played in this by the attitudes of individual judges, such as Windia J., not just regarding the merits of particular decisions, but also regarding the appropriateness and desirability of maintaining uniformity across jurisdictions on the one hand, or of developing local law on the other. I'm sure that's right, and it strikes me that the same is clearly true of developments in equity, where the attitudes of judges such as Mason CJ and more recently, for example, Gummo J, made a very significant impact. Comparing the tort law doctrine and the equitable doctrine of the two jurisdictions, it seems to me that there are bigger divergences in equity than there are in tort, exemplified by the rules of the two jurisdictions regarding equitable estoppel, unconscionable dealings, remedial constructive trusts. I won't go on. Would you like to make some observations in response to that contribution, please?
Thank you, Charles. So I think that's certainly true. There's been greater divergence in equity. I referred to an article, or actually a chapter in a book by Paul Finn, who actually notes that the newfound liberation that the Australia Act gave was first realised in private law in the High Court's equity jurisprudence. I mean, there's a long sense of separateness, I guess, certainly in New South Wales, by the failure to adopt the Judicature Acts until 1970. So you've got a core of doctrine existing in New South Wales, which is also different for procedural reasons, in some cases substantive reasons. So perhaps they're drawing on that. Look, this is the start of a wider project. It so happens that the actual cases where these issues were raised were tort cases, which was a happy coincidence for me. But I don't think it's the only situation where some of these changes can be mapped. I didn't have time in the lecture tonight, but I also think there are reasons why we see greater divergence since 1986 as well, because I think there's a symbolic importance of 1986 for empowering Australian judges to go further. And once you lose British race patriotism as an underlying feature, the necessity or the power of arguments for consistency, I think you're on a different plane. In a sense, that's what I was trying to argue tonight.
All right. Look, we've got one other question from Paul Mitchell, and we'll have to make this the last question because we're running against time. Up until MLC and Evatt, was the Australian judiciary broadly content with the decisions of the Privy Council, by contrast with its feelings about House of Lords decisions?
That's a very good question. I mean, broadly, content is a question that has to be culturally unpacked, I guess. I mean, there are examples from the 1960s, and so Quinlan's case in occupiers' liability is, I think, resented is might not be too strong a term. This is an interesting development which is then crushed. But actually, Windia himself says in a case, Munnings and hydroelectric scheme from 1971, with I think fairly clear indication that he's not happy with what's happening, but we have to accept the Privy Council's authority as part of our heritage. As you know, Paul, I've written for an earlier period that Australian judges were very good at avoidance strategies, so they could distinguish high court cases as they are necessary, or in some cases just confine them to a different area of law. So I think it's true to say that there was, it would be wrong to say that there was somewhere or other a period of happiness and a period of dissent. I think there's more continuity than that broad distinction would suggest.
I'm going to try the patience of those present by asking one more question from Charles Mitchell, which is a follow-up question to the question that you addressed before. Professor Mitchell says, I wonder though if you agree with that or think that the differences in tort are just as large by now. I also wonder whether the story on the equitable side is also different because of the comparative delay in introducing judicature reforms in Australia, and especially in New South Wales, with the result that equity jurisprudence continued to develop there in a strikingly different way from how equity developed in England in the 20th century.
Yeah, so I think, Charles, I mean, that latter point must be right. There are specific factors which influence the development of equity in Australia than as compared to the development of equity jurisprudence in England. As we're running out of time, we can deal with the substance a bit more detail later. But all I'd say is I think while there are those structural differences, I think what changes in the 1960s and starts with the culmination in the Australia Act 1986 is a greater willingness and assertion to place those differences as differences rather than trying to put them as part of a broader common law or applicable to people who came from common law systems. There's a greater willingness to recognise difference, I guess, rather than a uniformity.
I wonder if I might be bold enough to make an observation of my own. Certainly in the 1980s, and I think since as well, equity scholarship was, in my view, much stronger in Australia than in England. So many of the great equity textbooks and practice books were the product, in particular, of Sydney and Sydney University and the Sydney Bar, much more so than London at that time. One should never underestimate, in particular, the huge impact across the common jurisdictions of Margamo and Lehane. No textbook like that has ever been written in the United Kingdom, certainly wasn't at the time, and it became very celebrated here and filled a gap that English scholarship had not filled. Professor Lunny, thank you so much, and to those who participated in this seminar. It's been very nourishing. It's been extremely interesting. I think we will all consider we have had an extremely intellectually satisfying hour or so. Thank you, ladies and gentlemen, and thank you in particular, Professor Lunny. Good night.